good afternoon to in-house counsel and in-house legal professionals from all across North America and the world. Welcome to In-House Connect. My name is Shai Mahani. I'm the CEO and co-founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for spending your breakfast time or your lunchtime with us, and special thanks to our wonderful sponsors, Tangibly and DLA Piper, and our fantastic presenters today, Chris Buntel and Nicole Endejann, who are going to teach us how to navigate between patent and trade secret protection for life sciences companies. This is our 34th event of the year, and I'm wondering, are you here for the first time, or have you tuned into an IHC webinar before? And shout out to New Jersey and amazing Newport Beach. Thank you, Joe, for chiming in. Let's get to today's program, which is navigating between patent and trade secret protection for life sciences companies. We have an awesome panel starting with Nicole Endejann. Nicole is a partner in the Philadelphia office of DLA Piper, where she focuses on intellectual property matters, including developed product exclusivity strategies, strategic patent prosecution and counseling, due diligence, and transactional support. Her clients include those in the pharmaceutical, biologic, nutraceutical, cosmetic, medical device, and other health and life sciences fields. Nicole conducts IP due diligence and counsels on transaction documents involving IP, such as license agreements, collaboration agreements, and mergers and acquisitions. She also advises such clients on the interplay between the FDA and patent law on pharmaceutical, nutraceutical, dietary health supplement, and medical device products. Nicole also provides strategic counseling on best practices for the creation and management of robust, value-driven intellectual property portfolios. Next, and joined by her, is Chris Buntel. Chris is an intellectual property attorney with over 20 years of experience, and he is the co-founder and CIPO of Tangibly. Tangibly is the only SaaS platform dedicated to trade secrets, arguably the most important class of IP assets. Chris is passionate about trade secret management and education. So we have a wonderful panel for today's program. Without further ado, I'll turn things over to Chris to get us started.
Thanks so much, Shai. It's great to be here. And I like patents. I'm not anti-patent by any means, but I love trade secrets. So this is just a great topic for us to talk about today. So next slide. Okay, so yeah, go back to the agenda.
Yeah.
Okay, so today we've kind of broken the schedule down into 6 parts. The first one is just to give an overview of trade secrets. We recognize that some of you in the audience are probably experts already in trade secrets, but maybe others are earlier in your trade secret journey. So we just want to kind of level set the audience, and then we can dive into the good stuff and talk about why patents historically were extremely important, especially in life sciences and pharmaceuticals. I talk about something you've probably heard a lot about, the Orange Book, and how important that is to the FDA process of approving new therapies. And then there's a lot of disclosure requirements, given that life sciences is such a heavily regulated industry. There's some trade-off there in terms of what you have to disclose. Then the 5th part is something I'm really excited about, this idea of patents and trade secrets. And a lot of people have the misconception of you can only pick one. So if you're on the patent road, you can't be on the trade secret road, and vice versa. But Nicole and I both very strongly believe that the two of them can be used in a complementary manner to give even more value or even more protection. And then at the end, we're going to talk about some interesting case law. There's more and more of this every year, and there's some really interesting fact patterns coming out, and a lot of trade secret law is evolving. It's a very active field. So we've got a great agenda for you today. Next slide. And just to let you know, Nicole and I will be bouncing back and forth as we go through the topics. But on this slide, you can see an iceberg, and I absolutely love the visual of an iceberg. And as we all know, the amount of the iceberg that you can see is only the very top slice of the iceberg, and most of it is hidden under the water, waiting for the Titanic to come along. IP is really very similar. So you have the traditional government registration types of IP, like patents, trademarks, and copyrights, that are very visible. You can go on the website, you can look up a lot of information. There's great transparency around the government filed forms of IP. And everyone kind of understands the story. Law firms know how to help clients. Clients know how to use them. There's lots of great software and support. So that's kind of the easy part. But then it gets really interesting when you go underneath the water and look at the rest of the iceberg. And there's a huge, huge amount of stuff that is super valuable to companies, but probably is not protectable by patents, trademarks, and copyrights. Things like financial data, customer lists, vendor relationships, margin data, and pricing models. All of these things, if your competitor found them out, it would be very bad for you. You'd be very upset and you'd probably suffer a lot of damages. But trade secrets are actually a wonderful way of protecting this. Next slide. And we've really seen a shift in the last 5 years or 10 years or so, where information is suddenly where all the value is. It's not like in the past where you'd have factories and machinery and a lot of hard assets being your value. And nowadays, it's really data and information. And the legal system is kind of reflecting that. So starting in 2016 and going forward, there's been a lot of new legislation, new statutes built around providing protection for information and trade secrets. And again, it kind of reflects what's happening in the marketplace. So it started in the US in 2016 with the DTSA, which made trade secret misappropriation a federal case instead of just at the state level. And then other countries like Europe, China, and Japan have followed suit. Even a month ago, India, surprisingly to me, announced that they're drafting trade secret statutes. And it was funny, I was in India visiting some law schools and was asked, when will India jump on board? And I thought it would take years from now, but even they're catching up. So it's really showing the importance. Now, in terms of what is a trade secret, we always think of patents as being a very broad category. Like you can patent a lot of things and a lot of methods of doing things, but the scope of trade secrets is even bigger. And in my mind, you can divide the world of trade secrets into two buckets. So one is technical, so all about products and manufacturing and things like that. And those of us who are IP lawyers or patent lawyers, kind of, from our early careers, we've been trained to think about protecting technology, protecting new products, or better ways of making or using things. But the other bucket of trade secrets, we often don't kind of naturally think about, and that's the business trade secrets. And in some cases, those can be as valuable or maybe even more valuable, and they're litigated all the time. And in terms of what defines a trade secret, if you look at the definition in different countries, so US or Europe or China or Japan, it's remarkably consistent. So the definitions, they vary a little bit, but overall, they're all covering the same thing. And you'll see that there's this three-part definition. So the first is it's not generally known. It's kind of a softer version of the patent absolute novelty requirement. So it's not quite as harsh as that, but still it has to be a secret. That's part of the name trade secrets. The second one is basically that it has value. And to me, that's a little bit obvious too, because if something has no value, you probably don't care and you're not going to be upset if it gets stolen. So the value could be financial, could be cost savings, could be helping you comply with ESG requirements. There could be a lot of different ways of saying it's valuable, but it has value. The third part of the definition is where things either get challenging or interesting, depending on your perspective. So you'll see this phrase, reasonable measures, and we'll probably come back to that a couple times during the hour. It says reasonable measures are taken by the trade secret owner to protect that information. And you'd think, okay, I'll flip the page and then it will say reasonable measures means X. Guess what? It's not there. And you flip the page again and it's still not there. It's never defined because it's a very fluid definition. So if you have a trade secret that is the lifeblood of your company, you'll protect it incredibly well. Whereas if it's a marginal value trade secret, you might proportionally protect it less. Also, if you're a brand new startup company that's struggling to survive month to month, you don't have a lot of resources to put into protecting your trade secrets versus if you're a huge multinational company like Airbus or Toyota or GM, you have armies of lawyers and huge legal budgets to protect your trade secrets. So all of that is actually reasonable. It just depends on the context, which for me makes it interesting and fun. Next slide. So I mentioned that trade secrets can take a lot of different shapes. So there's technology ones like methods and processes, ways of assaying, like even QC and QA testing can be considered a trade secret, but you'd probably never patent it. Things like software can be a trade secret. Even like business plans or competitive intelligence, you would never patent that or trademark or copyright it, but it's an incredibly valuable asset and trade secret is a great way to protect them. And things like customer lists or vendor lists or your relationships with collaborators, you wouldn't patent that. Like that's just kind of nonsense, but it makes a wonderful trade secret. And then the last one, a lot of people have never heard of, and it's this notion of negative know-how. Ever since birth, we're kind of trained to think in terms of success. So, I won the contest, or I was the best at a particular sport, or I made a great product that made millions of dollars. Negative know-how is very counterintuitive, and it's this idea of knowledge of what failed has value. And at first it sounds a little crazy, honestly, but things never work the first time. So like you can't go to your R&D team and say, I want you to build a new product or create a new drug. And the first time they go into the lab, it works perfectly. Real life doesn't work that way. They have to fail 75 times in a row to get to the one final ultimate success. And negative know-how is the knowledge of those 75 things that didn't work. And you might wonder, well, why is that valuable? Because it's failure. And I would never patent a failed experiment. Again, that's kind of nonsense. But if a competitor knew what 75 things not to try, they would have an incredible advantage and would be able to leapfrog all of that time and money and effort and jump right to the good stuff at the end that works. So again, I'd encourage all of you to keep that in mind because it is a bit of a different way of thinking. Next slide. And patents, sorry, go back quickly. Patents and trade secrets are very different. They're totally different animals and they each have different pros and cons to them. But one of the things that I really like is trade secrets are global. It's not like patents where you have a patent in the US and a patent in South Africa and one in Singapore, and you'll end up with 10 or so all corresponding to the same invention or same technology. Trade secrets have the ability to be global and the ability to last a very long time. So they are very different. Next slide. And just briefly on trade secret misappropriation, I apologize, there's a lot of information on the slide, but it's very much analogous to theft. So trade secret misappropriation is more like if someone breaks into your house and steals your jewelry or steals your watch or steals something valuable, or they use it in a way that they're not authorized to. So you might allow someone to rent a spare bedroom in your house, but you're not allowing them to run a business out of your house, for example. Trade secret misappropriation works kind of the same way. So like what usually happens is an employee is getting ready to leave to go to another company or a competitor. And at 3 a.m. the day before they quit, they download 5,000 files onto a thumb drive or their Gmail. Like that's a very common scenario. Or it could be like a partner. You go to someone to help manufacture something or do some QC or QA work, but then they use your information to help another client of theirs that they weren't supposed to. So again, it's very much kind of a fairness mentality versus patents, which are more like landmines, where someone steps onto your claim and then your landmine explodes and causes some damage to them. Trade secrets, it's a much more personal thing. Next slide. Okay, here's our first of 2 poll questions. So we're wondering, in the recent past, has your company been in litigation? And if so, has it been patents, trade secrets, maybe both? Or if you're the lucky few, you haven't had to be in litigation so far. So we'll take a minute or so and see how this polls out. So this poll is interesting. A lot of you, 64%, have not had to be in litigation. So congratulations, you're doing something right. And it looks like very few pure trade secrets, and then some mix and some patents. So interesting results.
Yes, absolutely. All right. So one of the questions, folks ask, because we are talking about, whether or not we should patent, or we should try and keep something as a trade secret. How do we evaluate these? Oftentimes, though, in the life sciences, especially in the biologics, small molecule or drug space, medical device, there is a lot of emphasis on patent protection. And kind of the question is why? Why does everyone orient that way? And I think we've all seen in the news very recently, there's been a lot of discussion, and the data does show that with the advent of kind of the patent systems across the world, and the US being one of the key countries that really does provide protections around patents and really helps those inventors, that you're seeing much more innovation. It's partly why we have been historically a leader in innovation and becoming one of those first world countries, because we have this system that really, at the end of the day, the patents are meant to be there to increase the useful arts. And so there is a requirement to kind of provide a disclosure of what your invention is, what your new technology is. And for that disclosure, if you comply with that disclosure, and in fact, that invention is new or novel, and it's not obvious or inventive, then you are given this, time period by which you can prevent others from practicing that invention. But it's all built on a requirement of disclosure so that people can learn from it and then innovate on top of that. So we do have this emphasis on patents. We also see the fact that in our industry, in particular in the life sciences, as Chris mentioned, highly regulated. And that's because you're dealing with, something that's impacting the social welfare of, the country and its citizens. And so they're going to highly regulate that access to the market. They're going to kind of tell you, in this case, the FDA is going to provide rules and regulations in terms of what controls you need to have in order to access that market, what your product needs to look like, what the characteristics need to be, how you are allowed to use that product, how you're allowed to market it, how you're allowed to sell it, and then maybe even the speed to which you access that market as well. They're kind of controlling all of that because they want to make sure that these are, at the end of the day, they are supposed to be safe and effective for use. But with all that control comes all of this required disclosure to the FDA, and some of which, and you're going to see as we go through here, a lot of this disclosure is not only to the FDA, but FDA turns around and then discloses it to the public. So trying to kind of figure out, when do you need to maybe file on something, or when you have the ability to possibly protect it as a trade secret, you don't have to file a patent application on it. But some of it, your hand is forced. If you want to apply to get approval to access this market, you may need to tell the FDA, and the FDA is in turn, they may publish it. So you might be forced to patent, trade secrets might not be available. And that's a little bit of what we're going to touch upon. And then, as Chris mentioned before, patents are the tip of that iceberg, right? They are easily evaluated by investors. They're transparent. People can review them, see them, whether they're talking to you or not. They can access some of that information on their own to kind of evaluate it themselves. So there is definitely a push. A lot of investors will say, if you don't have patents, I'm not going to invest. Frustrating kind of investment proposition, but it is often true. They want to see that there are some patents there, and trying to educate investors to say, look, there are trade secrets here and these are meaningful. They do have value, but it's hard to basically provide that information to them so they can evaluate it, because you need to keep it as a trade secret. So that's another reason why. And as Chris mentioned, some of the places that you see a lot more trade secrets in the life sciences tends to be in the early research and development efforts. That's filled with a lot of that negative know-how, which is one of my favorite topics of trade secret protection, that negative know-how. It is extremely valuable, but tends not to be, it's not going to be the product. So hard to patent that, because often those are the things that do not work, but they are extremely valuable to know, because you aren't, if you were a third party, you would avoid working in that space often. So if you knew about it, so keeping that back and holding that back as a trade secret can be very useful as well. So if we look at, just generally speaking, when we look at small molecule protections and small molecule patents, Hatch-Waxman Act was passed and gave a lot of incentives for small molecules. And a lot of that is actually oriented, again, around patents. They actually wanted, I think, in part to emphasize and really encourage innovators to file patent applications, so that you're increasing disclosure. People are learning, people are innovating on top of that. And quite frankly, it allows generics to build off of that as well. So, through Hatch-Waxman, there were a lot of incentives given to small molecule developers, and a whole system that's set up that if you file patents and issue them on your product, and they cover your drug product, the drug API, that active ingredient, or the approved method of use, you actually list those in an orange book. We'll talk about that. And if you enforce them, you get an automatic 30-month stay. So there's kind of this benefit, so an encouragement to filing a patent application. And there are some rights that generics have as well to challenge the patents, all of this. So very much a back and forth on incentives on both sides of the innovators as well as the generics. In contrast, under the act that created what is now our biologics licensure, and then the abbreviated biologics license applications, so those ABLAs, or the biosimilars, there's a lot less incentive. A lot of people will say, oh, these statutes are very similar, but in fact, they are not. When you're talking about a biologic, as opposed to a small molecule, it's a much more complex molecule. These are things like antibodies, vaccines, gene therapy, toxins, proteins, which are very, very large. Think of them as polypeptides, so not little short peptides, but very large molecules, which all of these tend to be made through systems synthesized through biological systems, not chemically synthesized. And so because of that, it's kind of interesting. You see a setup where in the Biologics Licensure Act, there is much less incentive around the patents. They do have a mechanism where you can challenge patents that cover the biologics, but there's not a required, listing in an orange book, which we'll talk about in a little bit. There's not, and there isn't a requirement that you actually have the litigation at all, or have, it's what they call the patent dance, to actually decide what you are infringing or not infringing, or you designed around. They are not trying to push and encourage necessarily that, as they do with the small molecules. So very interesting piece. And I think they've done that because, in a way, they have recognized that for biologics in particular, they often say that the product is the process. Because these are such complex, large molecules, the way that you manufacture them can greatly change their activity and their characteristics much more than a small molecule drug. They realize that all of this manufacturing with all the detail, all of this is not going to be easily patented, but it's so important to the activity of that molecule that ultimately they recognize it is very important, but they don't require you or incentivize necessarily so much the patenting of that information. So a little bit of a different system there. So as I mentioned, the Orange Book, this is, the fun fact. I don't even think they make paper copies of this anymore, but it literally was, orange on the front. People would carry it around. And it is essentially lists all of the approved products, whether they are the reference listed products or branded products, or they are the generic versions of those same products. They list all of them in the Orange Book. And what they also list, though, and importantly, is all of the data exclusivity that FDA may have granted to the applicant, as well as all of the patents that you have listed in the Orange Book, which means all of the patents that cover your drug product, drug substance, the approved method of use, polymorphs, and formulations. So, but it's of that drug product that is approved. And this is a requirement. If you have a patent that covers your drug product, and upon approval, you shall list those patents in the Orange Book, because they want you to tell the world, the generics, what patents cover it so they know what to avoid or what to challenge. And you list those patents in the Orange Book 30 days after your product is approved or 30 days after your patent issues, whichever is later. But again, sharing of information, trying to get all that information out there. In contrast, that you hear about in the biologic space, a purple book, but very different. It is a list of all the FDA approved biologic products, as well as those biosimilars, which are kind of like generics, but it does not require you to list any patents at the outset, at the time of approval of your biologic product. There have been recently a change in the rules where they have decided, because of this optional, what we call the optional patent dance, where you can litigate if you are a biosimilar and the original biologic, and kind of fight through those patents and decide if the biosimilar infringes. With this optional patent dance, the two parties exchange lists of patents, and they kind of decide together which ones they're going to litigate, if at all. Those lists, if and when that happens, those lists are required to be now published in the Purple Book. So it provides you a little bit of information, but it's nothing that happens at the outset. So if you were the first biosimilar filer, you're not going to know until you receive the list from the biologics owner. So kind of a little bit different there. But now I want to touch upon, looking at these two systems, a fair amount of incentives on the drug side to file patents to protect your products, if you want to protect them, which you do. A little bit less incentive for biologics. You don't see that quid pro quo there between the biologics and biosimilars as you do with the small molecules and generics. But what we do have is, interestingly, through this process of, testing your products, there are a lot of disclosure requirements that are set forth by the FDA. And so this is just a summary of a couple of them. When you file an IND, as an example, which is your application to allow you to go from animal preclinical testing into humans, you are required to file all that, an IND application with the FDA, which they will essentially approve to allow you to go into humans. That will consist of a lot of animal data. Most of that will not be published, but they will publish a little bit of it if you have already published some of it. So on IND filings, a little bit of that is in your control. A new one that I think is really interesting is clinical trials. So for the longest time, if you run a clinical trial in the US or Europe and some of the other major countries, but let's just focus there, you need to list and submit your clinical trial protocol, or at least a summary of it, on clinicaltrials.gov. This is when, you're testing your product. Do you're not sure, does it work or does it not for its indication? But interestingly, you now have to submit a copy of your protocol or summary within 21 days of enrollment of the first patient in a trial. So, and this is really, it's for mostly phase 2s and phase 3. Phase 1s are exempt, where you're just kind of testing some potential doses. And then the relatively new change is you now must submit a summary of the results within 1 year of completion of the, obtaining data on that primary clinical endpoint. And so this is a really big change from our perspective on the patent side, because it used to be that we might have a client conducting a clinical trial. We want to file on their method of use, and we thought, well, we could keep those results back. We may not share them. Well, now you're required to publish them in summary format on clinicaltrials.gov. Now you can do it essentially within 1 year of completion. You can get a 1-year extension, but then after that, it has to be published. So again, another way, forcing our hand to share data, share information. DMFs are an interesting piece. These are drug master files. This tends to be used by third parties who are supplying something to others. So they don't hold the drug application, but they supply a critical ingredient like an excipient, or maybe even the active ingredient. It's something kind of interesting. This is a way for them to apply, but the drug owner doesn't have access to that information. DMFs are kept very much top secret if you file them with the FDA. So that's an interesting tool to use. And then with NDAs and BLAs, and I think this is really important, the applications themselves, there's a lot of data that you submit when you apply to get approval or licensure from the FDA. Each of these, they have very similar regulations, but they're titled differently within the Code of Federal Regulations. The one around NDAs and ANDAs, they talk about that is entitled sharing of information, availability, for public disclosure of data and information. Whereas the reference for BLAs is entitled confidentiality of data and information. So you see this interesting kind of approach where they've decided that they want the drug information, small molecule information out there. They're leaning towards disclosure. It goes out unless. Whereas with biologics, they are thinking more, it's not disclosed unless. But at the end of the day, there is a mechanism by which for any of the information that you submit in an NDA or a BLA, it does eventually, a package of it, a portion of it does get published on FDA's website after approval of your drug. But there are pieces of that you can request that they be treated as confidential, treated as a trade secret. And you need to identify it at the time of disclosure to the FDA or within a reasonable period thereafter, where you tell them, this is something that I want, I'm treating it as a trade secret, I want to keep it back. And in fact, FDA does not really verify or confirm that it's a trade secret. Now, if they've seen it out there that you have publicly disclosed it, then they will not treat it that way. But again, that's not what they're really in the business of doing. So, when you do see these files that are out there on FDA's website with the approval packages, you'll see a lot of information redacted, because as an applicant, you can actually provide them with, okay, this is what I want you to post. This is the version of it. So something that's really important, because you'll see in a little bit, we'll talk about a couple of cases that have gotten into some of this type of information and it being treated as a trade secret. Again, their definition of trade secret in the regs is what you would expect. Any commercially valuable plan, formula, process, or device that came out of substantial innovation or effort. It could also be of commercial or financial information. And at the end of the day, even though we have all these FOIA requests, there is exemption number 4, which prevents basically the government from disclosing or using anything that was defined as or identified as a trade secret or confidential when you submit it or reasonable period thereafter from using it other than to evaluate the application for whatever purpose that you provided it in the first place. So an important piece to kind of be aware of. And again, you see it in other sections of the statutes where, government employees are prohibited from revealing this information or using it in any manner other than for what you submitted. So I think, so at the end of the day, as Chris mentioned, we've got a lot of these in the drug space, biologics, medical devices, a lot of requirements of disclosure, and we know that FDA is going to publish this information once you get approved, right? Which is our end game. So, how is it? And a lot of incentives as well for patents, and investors want patents. So why are we even thinking about trade secrets? And can we do that? When you file a patent application, you have an obligation to kind of disclose to that patent office what your invention is. So how do you kind of balance those two? And there seems to be a lot of tension between those two. But at the end of the day, there are different ways that you can approach this, in kind of protecting and designating certain things as saying, this is going to be a trade secret, whereas this is something that I'm going to focus patent protection on. A lot of that is understanding what will need to be or will inevitably be disclosed. Your clinical trial data, your protocol, and the kind of summary data of the endpoints and the efficacy and the safety are going to be disclosed. Whether you like it or not, you're going to be required to share that information. So in all likelihood, those things need to be patented. Your drug product, maybe the biologic, that molecule in and of itself, there are disclosure requirements again when it gets approved. There's going to be a description in the package insert of what the product is, what that active ingredient is. So patenting that would make sense because those things inevitably get disclosed upon approval. But what doesn't get disclosed? So some of this information that you're going through, again, the early R&D, all of your negative know-how, that can be set aside. Early kind of platform technology as well. Sometimes some of that is not really amenable to patent protection because it's kind of big, broad, sweeping concepts and mechanisms and things like that. Really not, easily patented given the kind of the state of the patent system right now. So those would be things where you pull back. But manufacturing, particularly around manufacturing and some of the testing, those are some really interesting areas where you will see a lot of trade secrets. And that's pretty much the area, if you look back at the regs and what they say they will treat as a trade secret, especially in the biologic space, it's all the manufacturing information and information around kind of quality control for, manufacturing your products. That in particular is an area that is really amenable to trade secret protection. And so, that would be one of the main areas where you would look to. And I think the other thing is that if you generate improvements after initial filing and you kind of are continuing working on something, every once in a while you figure out that there is, an improvement there or a more critical excipient that you need. Maybe you decide I'm going to hold that back and not necessarily file a patent application on it. Again, depending on what the subject matter is, that might be possible. And you're not required to update your patent application as time goes on. It's only at the time that you file do you kind of tell them what you need to know. You need to describe your invention and arguably the best mode of your invention. But after the filing, you don't have a duty to update. So improvements on things can also be an area where you might look. So, and I think, what's interesting is there's a case study out there with a product called, it's an older one, and it's just been out there for so long that people look at this, but Premarin's a product that's been out forever, since like the 1940s. There were patents on it. They expired in the 50s and 60s. to this day, it still does not have generics out there because Premarin it's a hormone replacement therapy. It's made from pregnant mare urine, and they extract it using this, really secret process by which they extract and kind of isolate whatever these conjugated estrogens are that become the product. And even though those patents have expired back 50s and 60s, no generic competition to Premarin to this day. So there are ways where you can, between the two, you can kind of hold back information and make it very difficult for, generic competition or just other competitors.
And Nicole, I like this slide because it's actually a challenge to all of us in the audience to really think and be creative. There's a lot of CLEs and articles out there that talk about patent versus trade secret, or patent or trade secret. And really it's up to all of us on this call to step back and be creative and really see if there's ways to do both instead of just one. So it's great for all of us to think about after this session.
So second poll question. Thank you. So how has your appreciation of trade secrets, what should we say? How has it changed? Has it increased, decreased, stayed the same?
Yeah, this is kind of a temperature check for Nicole and I to see how well we've done. But the first two are easy, so either increased or hopefully not decreased. But then it could stay the same where like you are super excited about trade secrets and you still are, which is great. Or you don't like trade secrets and you still don't like them, which maybe this isn't the right CLE for you. But it's an interesting poll.
Mm-hmm. Yeah. Well, it's good to see. Does everybody see the results? I don't know how that, or do I hit the share results? Maybe I do that. I think you guys can see it, share results. So I think the majority of people, it has increased. A few has stayed the same because they are very knowledgeable about trade secrets, which is great. So we'd love hearing from you as well. So appreciate that. Let's see. So I think we wanted to get in just a little bit on a couple of cases that we think are really interesting that are relatively recent. So Chris, did you want to talk a little bit about Genentech?
Yeah, so we actually have three cases and we'll kind of take turns between Nicole and I. The first one, Genentech versus JHL, the story itself is interesting, but the outcome, the end result, I think is even more interesting and worth talking about. So one of the reasons I like reading trade secret cases is they're very personal and they tend to be kind of interesting or entertaining compared to patents. Like patents are usually big entity versus big entity or university versus big entity. And they're kind of impersonal. Like someone made a product, infringed a claim, got sued. Fairly straightforward. With trade secrets, again, it's, to repeat myself, it's kind of like someone breaking into your house. It's usually down to one person or maybe a small group of people that are doing something that's arguably wrong. And JHL, the story again is kind of interesting if you have time later on to read it. But they were recruiting people who left Genentech, and even there is one example of they had an employee stay at Genentech and then secretly work for JHL on the side. So it is kind of an entertaining story. But I really picked and included this because it not only has a civil aspect, but criminal as well. And one of the great things about trade secrets and makes stealing them a little scary for the defendants is the possibility of having criminal action taken by the government against you. So normally for individuals, there's a cap of $500,000. And what's really scary is up to 10 years in prison. And then it gets even worse if it's done for the benefit of another country or an agent of another country. The 10 years in prison can go up to 15. And like, I'm willing to do a lot for Tangibly, and I'm sure Nicole is willing to do a lot for DLA, but going to prison isn't one of them. That's a bridge too far for both of us. And yeah, for JHL, both the CEO and COO have a little bit over 1 year in prison, which is still for me too much. And then 36 months of supervised parole afterwards. So it's interesting that if you're the trade secret owner, you could try to pursue criminal charges against the alleged trade secret thief. And then again, if you're considering taking trade secrets, this might be a good deterrent from you. And there was a settlement on the civil side between JHL and Genentech, where basically that head start or accelerated process that JHL was able to do by virtue of getting trade secrets from the employees, they basically agreed to stop pursuing those products. So it was actually a pretty painful result at the end of the day, but it shows that trade secrets are enforceable and you can get kind of good results if you manage your trade secrets well. So this one is definitely worth reading. Nicole?
The second one that we have up here, it's not directly in, I would say, under the auspices of FDA, but an analogous agency, the USDA, they administer the SNAP program, which is the food stamp program. And there was a FOIA request by Argus that was made where they wanted information on all of the companies that participate in, they wanted information on kind of the amount of money they were making, all this financial information, all this commercial, so more business information on this one, but it was requested under FOIA. And interestingly, the district court decided that they were going to look at this and look at the exemptions because, of course, USDA said, no, we're not going to provide this because this falls under exemption number 4. It's, trade secret or commercial information that we treat as, privileged and confidential, not going to disclose it. And the district court and even the 8th Circuit both sided with Argus and said, no, we're going to compel disclosure of this information because USDA, you haven't shown or demonstrated that there is going to be substantial competitive harm if you share this information, because all of it would be shared across the entire program. Everybody's going to be in the same boat, all of that. And then actually the Supreme Court, it went all the way up to the Supreme Court. And it was an advocacy group on behalf of some of the retailers that had stepped in, demonstrated they had standing and said, wait a second here. No. That's not the appropriate test. And ultimately, the Supreme Court did agree with them. And they said, look, under FOIA's exemption number 4, if the information is customarily kept confidential, so it's the kind and the type that you typically would keep confidential, and the government's provided assurances that it would keep it confidential going forward, then, you don't have to demonstrate substantial competitive harm. It's enough to kind of assume that there is going to be competitive harm by sharing that information. So kind of making it, the idea that it's a little bit easier, at least under this rubric, that you can keep something a trade secret if you can show there's kind of an expectation that this is the type of information that should be kept secret in that system. So I thought that was kind of an interesting case. And then Vanda is one of our favorites. I don't know, Chris, do you want to start out or?
Yeah, I'll start on Vanda. So when we were building this slide deck, I think both Nicole and I picked Vanda as our first choice. It's a really interesting case that's ongoing, but it's not your traditional theft of trade secrets. So there was no evil ex-employee or people hacking into databases. Vanda was pursuing registration with the FDA and submitted a whole bunch of the required disclosure information that Nicole mentioned. And then the FDA shared that information with another company. So it's not your traditional trade secret theft because the FDA is not a commercial entity. They're not making drugs or selling drugs. And what's interesting is that Vanda, because they couldn't say it was a normal misappropriation of trade secrets, they're pursuing a very creative and kind of, I never would have thought of it myself, approach of saying by releasing the information to that other company, it was basically a taking under the Fifth Amendment. And this is the same concept, if you're not familiar with it, of, if the government wants to take your land, like if they want to build a railway or a highway through your backyard, there are ways that they can take that from you in exchange for some fair value. And so Vanda is actually taking that same idea of saying, the FDA, you're not a competitor, but you basically took the value of that information and destroyed it, or gave it to someone else, so you should compensate us. So this is, again, it's an active case. It's really fascinating, and their lawyers are amazingly creative people. I'm very impressed.
Yeah, it is. I think there in particular, we were talking about this, some of the, information that tends to be in the chemistry, manufacturing, control section. So the CMC, and this in particular was information on specifications for dissolution of the product, as well as information on kind of specifications for the impurities that might be found in the product. And Vanda was the reference product. And what happened was, when Vanda went through its approval process, they had provided, their own specifications and said, look, this is what we think, the dissolution should be and the impurities, yada, yada, yada. And FDA came back and said, I don't know, why don't we, and they basically narrowed some of the specifications to say this would be allowable. And Vanda agreed and said, okay, fine, we accept that product was approved. Well, then come along 4 different generics, and they all filed with their ANDAs, and their specifications for these same things were not the same as Vanda's. They probably were doing something similar to what Vanda had originally proposed as well, because I'm guessing it was probably more within the norm. But for whatever reason, FDA wanted tighter specifications on these characteristics. And so there's actually evidence in the file where it says that the FDA reviewer went back, checked the Vanda information, confirmed, these are the specs, and went to each of the generics and said, no, I need you to have these specs, after checking and maybe even identify that they came from the Vanda application. And so, as Chris mentioned, it's under the, kind of a takings clause. One of the things, it's just at the motion to dismiss, which was denied. And so this case is ongoing. So we're going to continue to watch it. But one of the interesting pieces is, do they, Vanda, actually have an interest in this trade secret? Is it their trade secret? Because it was actually suggested by FDA, and then Vanda accepted it. And so I think there's a little bit of question there on, is it really a proprietary interest that they can protect? Is it really theirs? Because they didn't start out with it, but they did accept it. I think that's something that's kind of interesting, but it does identify some areas where, let's just say, set that aside, had it been their idea, this is the dissolution specification, impurities, all of that. These are areas that can be kind of identified as trade secrets and will get redacted when, after the product is approved, would get redacted in that summary information that's being published. So interesting case to continue to watch, because, it might change how, the government and FDA will approach kind of reviewing some of these applications. Are they allowed to go back and review kind of the original reference product or the original biologics license to see certain things to make the abbreviated filer comply? Are they allowed to do that if we identify at the outset that this is our trade secret? This is something really, really unique that we invested in and have value and clinically meaningful for the product. So
yeah, there's a lot of interesting case law, especially in life sciences. So it's worth following.
Yeah.
Next slide. I think we're kind of tight on time,
Yep.
so maybe we'll skip over this one.
Yes.
Go to the next.
Yeah.
So anyhow, thank you all for your time and attention. It's been interesting for us preparing and giving this seminar. Just for context, please reach out either through Shai or directly to Nicole at DLA Piper for legal advice. And then Tangibly is a SaaS platform designed to help identify and manage trade secrets. So we're more in the legal tech arena, but this has been a great session, and we'll stick around for a little while for some questions, but thank you all.
Thank you, Chris and Nicole. And folks, if you have questions for our panel, please put them in the chat. If you enjoyed the program, please let us know in the chat as well. There were a number of questions that came through, so I'm going to, in no particular order, I'll go with the first one. And hold on, sorry, it keeps jumping the chat. But I think the first question was from Jacob. Am I remembering correctly that the claims in a patent are supposed to allow somebody reasonably skilled in the art to reproduce the invention? And how does that work in examples like the hormone replacement drug?
Sure. So, and I haven't dug into all of the specifics of that one to tell you exactly what, the process steps. Well, obviously we don't know some of the process steps, but all of that to look at what was patented versus what might not have been. But you are correct in that when you file a patent application, at the time that you file your application, let's say in this instance, it's about a composition that is a pharmaceutical composition made up of these esterified estrogens. And they may have obtained them, maybe it was from a pregnant mare or maybe it was from something else, but they filed their application, and at the time they are providing information that, to your point, a skilled artisan should be able to reproduce that composition. So you need to kind of identify the structure, the makeup of what it is. So they probably are able to identify certain of the estrogens by chemical structure of what's contained in there. But interestingly, they may not have disclosed at the time the process by which they extracted it from the pregnant mares in a manner that was actually compliant with FDA requirements. So they may have said, oh yeah, you can, it might be a very, very rough way. So they may have said, yeah, I don't know how you would do it, but you'd collect the urine and you'd filter it and you'd, do like 5 simple steps. And even though it allows you to arrive at a composition, but it doesn't necessarily have to meet the extra requirements of FDA to be, like I said, GMP compliant. It might not be the best way of obtaining the estrogen. So you tell them what you know, as long as it's enough for somebody to be able to do it. It just doesn't have to be in the most efficient, best manner possible. And so in all likelihood, what they were able to do was that they disclosed some of the information on a way to capture it and, filter it and all of that. But over time, they probably developed things that they needed to do in order to comply with FDA requirements on purity and all of that they never shared, because that was done after they filed the original application. So that probably is how some of that went down.
All right. One more question. Stephanie is unclear about how to deem and secure protection for information that the company considers a trade secret. And Stephanie, I'll let Chris and Nicole weigh in generally here, but we do have a webinar coming up in a couple of weeks with Chris. Chris will be back with some trade secret experts or additional trade secret experts that will definitely tackle that question. But any thoughts on Stephanie's question?
Sure, I'll start out. And trade secrets are a bit more of a challenge than patents, trademarks, and copyrights, because there is no official procedure. There's no government filing. There's no, you pay a fee and you get a registration in return. It's very much DIY, like do it yourself. And we formed Tangibly about 4 years ago to address that need of coming up with a SaaS platform that helps you make it at least easier. I mean, it'll probably never be totally easy, but much easier than just doing it yourself on Word or Excel. It's a huge topic. I mean, I could probably talk another hour just about best practices and how do you catalog and manage your trade secrets in a way that either reduces your risk of problems or puts you in as good a position as possible to enforce those rights if something goes wrong, if someone does steal your your trade secrets? So it's a great, simple question with an incredibly long answer, but feel free to reach out either directly or through Shai, and maybe we can talk offline. Great question.
All right. All right, Nicole, we'll go to you for closing remarks.
Well, as Chris mentioned, this is always an area where, I think being creative is necessary, because you're trying to kind of not only think about where you are right now, but where you're going to be, in a year, 2, 5, 10 years. I mean, for a lot of these products, it takes so long to get to the market, where you're going to be and what the requirements will be in the future. And so, trying to understand where, not everything. I think, the Premarin example, that is an extreme. I mean, I think that's very much an extreme, but there are a lot of different pieces that you can identify as trade secrets along the way. And if you have a very good system that you kind of control and that you are staying on top of, you can derive value from that information if you do go through some reasonable measures to protect it, not share it, not disclose it, and really get some value out of it and start to articulate. And I think you're starting to see this with all the cases that are out there in the litigation space, that there is a lot of value in these trade secrets. And so I think investors are starting to get a little bit more savvy about that, but there is some education that is needed, definitely. So, we're trying to get that out there, but it's not so easy, because it can be a little bit complex and a lot of differing kind of driving factors, especially in this space. So I'm just trying to navigate both of those.
All right. All right, great. Thank you so much. Chris, any closing remarks?
Yeah, just a few words. I mean, I think identifying and managing your trade secrets is critical for every company in the country, in the whole world. And you always have more than you think. Like if you think you have 10, you have 100. But in the life sciences space, life sciences is special in a good way. And it does require more thought and more creativity, like we've said a couple times, to really maximize the value and protection for your products. So I think this has been a great topic, and it's ongoing, it's evolving. The case law is coming faster and faster because there's so many cool unanswered questions around trade secrets. So it's a great space to be in. Thanks.
Wonderful. Thank you so much, Nicole and Chris. This is a wonderful program.